Good day, we are Group 3 of 3MT Marketing Management and we're to present General Register number 184122, the case of the Bank of the Philippine Island Incorporation versus Norman and Angelina Yu. This case is about the propriety of a summary judgment in resolving a documented claim of alleged excessive penalty charges, interest, attorney's fee, and foreclosure expenses imposed in an extrajudicial foreclosure of mortgage.
Let us first identify the petitioner and respondents. The petitioner is the Bank of the Philippine Islands Incorporation, while the respondents are the couple Norman and Angelina Yu.
These are the case facts. The respondents Norman and Angelina Yu, the owner of 2000 Trading and 2000 Builders Corporation, requested a loan from Far East Bank and Trust Company amounting to 75 million pesos.
They used mortgaged several of their properties and lands owned by the 2000 Trading as collateral for the loan.
In 1999, the youths were having a hard time paying their loans, so they requested the loan restructuring to the FEBTC that merged with BPI, which they had granted, resulting in youths' remaining balance of 33.4 million pesos.
The youths are still having a hard time paying despite the loan restructure. Due to the exceeding remaining amount of the remaining debt, they requested the BPI to release some of the mortgaged properties in Legazpi City and Pili Camarines Sur, but later on the request was ignored. The youths withheld their payments in amortization, while the BPI extrajudicially foreclosed the mortgaged properties.
The youths took action to court against BPI and Magna Craft, which later the respondents engaged in a compromise agreement with Magna Craft, ensuring that 3 out of 10 parcels of land auction would still be owned by the youths. Because of the agreement, the respondents' case against Magna Craft was dismissed.
On October 24, 2003, the youths filed a complaint to BPI for the recovery of the following excessive charges incorporated in the price of the auction properties. The original amount of the foreclosure of the mortgage properties is 39 million, but the highest bidder is 45.5 million. BPI then admitted that the 45 million is the total of the auction properties, and the 409,000 difference between its bid and that of Magna Craft was in turn remitted to the clerk of court.
On January 3, 2006, the Regional Trial Court granted a summary judgment wherein the penalty charge of 36% was reduced to 12% per annum until the debt would have been fully paid, while the attorney's fee was also reduced from 10% to 1%.
BPI needed to provide sufficient evidence, but they failed to comply. That's why the Supreme Court has refused to reconsider and affirm the decision of the Court of Appeals. For the issues presented by BPI, these are as follows. Whether or not a case presented no genuine issues of fact such as to warrant a summary judgment by the RTC, and where summary judgment is proper, whether or not the RTC and the Court of Appeal correctly deleted the penalty charges because of BPI's alleged failure to comply with the Truth in Lending Act, correctly reduce the attorney's fees to 1% of the judgment debt, properly dismiss BPI's counterclaims for moral and exemplary damages, attorney's fees, and litigation expenses.
These are the following rulings of the court. First, the Regional Trial Court had to examine the following documents presented by both parties to solve the case, since those documents admit not only the existence, authenticity, and genuine execution, but are also uncontested. The trial court did not hold a trial for the reception of the evidence of the parties but a summary judgment. BPI contends that the summary judgment was not properly given to the many issues raised by the parties. BPI failed to name any document or item of fact that it would have been pointed out at the trial of the case.
Secondly, the court affirmed that the financial charges are disclosed if stated in the promissory note and did not include the handling charge. The youths also signed a disclosure agreement that does not include the penalty charges. Furthermore, they also signed a promissory note wherein the penalty charges are already included and required by the Truth in Lending Act. BPI had already 2.7 million of interest and had imposed the penalty charges of 36% per annum with the principal interest. Nonetheless, the court had the authority to reduce the penalty charges to 12% or 1% per annum when these are unconscionable and iniquitous.
Third, as for the award of attorney's fee, the Court of Appeals correctly affirmed to reduce it from 10% to 1% because it is not essential to the cost of borrowing. 1% is just enough due to BPI foreclosure expenses, and lastly, attorney's fee of 10% of the total amount is just inhuman. With these rulings, the court decided to deny the petition and affirms the Court of Appeals' decision to the restoration of the penalty charge of 12% per annum and or 1% per month of the amount due, computed from the date of non-payment.